copy, so I'm going to utilize my copy of Ryan on zoning. And thank you for your time tonight, Board. Sometimes there are legal concepts that interplay with ordinances. Legal concepts such as staying certain provisions during the pendency of litigation. And as Mr. Ferguson clearly stated, there is no Pennsylvania case, as Ryan notes, that states it's not voided. So there's no case that states the opposite. And in fact, Ryan is very clear when he says it is generally the thought that the common ordinance provisions that provide for the expiration of a, excuse me, I have my glasses fogged up, that provide for the expiration of a special exception or variance does not begin to run until litigation connected with the variance or special exception is finally concluded. This is best illustrated by the fact that although this issue arises dozens of times in Pennsylvania, no case holds that the failure of the applicant to seek a permit or bill during the pendency of litigation voids his approval. So there's no case that says otherwise, Board. Just like he wants to show you a couple cases that state that these provisions are acceptable, they are. But when there's an appeal, the entire time that the after the conditional use is given, that time period doesn't count against the applicant. The third paragraph in this section says, the policy behind the limitation on the life of a variance or special exception is to prevent an applicant from obtaining a permission and sitting on it. A sin that is not present when the owner's inaction is caused by the justifiable concern about the risks of pending litigation involving his right to obtain the permit. All of this is avoided by reading any limitation of the life of a variance or special exception as running from the conclusion of litigation concerning its propriety. The ordinance itself doesn't need to state it. This is a legal concept that you can read in conjunction with the township's zoning ordinance, and I would ask that this Board do so in this particular case. The appeal ended in this case in December of 2019. Within 1 month, the applicant sought its building permit in January of 2020. And I'd also like to state for the record that the actual time period for which this particular appeal of the building permit was filed is after the 30 days of whether he knew or should have known. If you go back and look at Exhibit 8A, the notice was given to Mr. Ferguson on June 12th. The appeal here with this Board was filed on July 14th. July 13th was a Monday, which would have been the last day to appeal. 30 days after even if you take that part of the facts as true, that was the first time he knew, that's 31 days. So I'd ask you all to consider the timeliness of the appeal itself and or to rule on the actual non-expiration of the conditional use in light of the appeals that took place during the pendency of it. Thank you. Are you all, do you have anything to say? Okay.
Yeah, just brief.
And again, Jeff Reese on behalf of Crown Castle Towers 09 LLC, just briefly without trying to restate the same things that you've heard now a few times over. The question before you today is not whether the zoning officer extended an approval that was previously granted, it's whether or not it expired. It's a simple issue in the township's point. I'm just going to simply restate and adopt that argument. But that approval never expired because of the appeal that was proceeding, that was filed by Mr. Sluciak, both in the Court of Common Pleas of Washington County, and then when he was not successful, in the Commonwealth Court of Pennsylvania, where again the decision of the supervisors was to affirm the grant of the building permit, or the conditional use approval. So I think there's another issue too that's the timing issue. So this appeal that brought this before you today, the township had indicated was filed on July 14th, 2020. When Mr. Sluciak was asked whether or not he was aware of the building permit having been issued after February of 2020, he couldn't answer the question. He said he wasn't good with timelines, and he couldn't recall exact dates. You have the sole discretion to determine whether or not he's a credible witness and whether or not you believe his testimony. And if you believe that he's not credible, then there's no witness other than him that can testify as to the date that he knew when that building permit was issued. And if it was issued any time, and he was aware of it prior to that, the June 12th date that the township's argument made regarding when his counsel found out, if he found out any time before that, he's time barred from bringing this proceeding today. And finally, the case law on the expiration that Mr. Ferguson had brought up in his Exhibit 13 from the Pennsylvania zoning law and practice of Mr. Ryan. None of that case law is particularly on point. It doesn't say that there was an expiration that was taken up on appeal. It's an issue that hasn't been decided, but it certainly makes sense that a zoning applicant, as he set forth in his recommendation, if they have an approval, but they're building at their own risk, why go through that risk? And if an appeal drags out multiple years past the 2 years that Cecil Township will even allow, if an applicant did ask, then they're barred and they have to come back and go through this whole process, waste everybody's time to relitigate the same thing so that the same end decision can be resolved. And I think that is a miscarriage of justice. That's not what's intended by the ordinance. That's not what's intended by the case law. And that result will not be appropriate. So again, on behalf of Crown Castle, thank you for your time tonight.
Ladies and gentlemen, once again, Joshua Lorenz and Minor Underwood Scott on behalf of Hidden Acres East Apartment Community, Inc. I want to thank you so much for your time this evening and for your attentiveness. I will not belabor the points. We would adopt the arguments and the positions that have been offered by both Cecil Township as well as Crown Castle. We believe that the appeal period has not lapsed, that the zoning hearing officer was appropriate and issued the building permit and did so in a timely fashion in accordance with the well-chronicled saga that started with the Board of Supervisors providing conditional use approval and ended when the appeal was finally decided, thereby freeing up Crown Castle to move for the building permit. And secondly, this appeal of the issuance of the building permit, as has been pointed out, is untimely. Mr. Sluciak identified during his testimony that Ferguson was his counsel on June 12th. They have represented that June 12th is when they first learned of the issuance of the building permit. If you go forward 30 days would actually expire on July 12th, which is a Sunday. If you move it forward one day, 30 days would be July 13th, a Monday. Exhibit A1 that they offered was the July 14th appeal of the building permit. The documents, even if you accept the testimony that they are offering, on its face, the documents on their face clearly demonstrate that the appeal of the issuance of the building permit is untimely. With that, we conclude and thank you for your time and consideration.
Anybody else have anything further to say?
Yes, thank you. Can I address?
Please, Dennis, he's not.
Well, there's a long history on this, Blake. A long history.
But it may
and
not
a
be
long
relevant.
history with this township. And this township now does not want to face what the ordinance is.
But we,
Mr. Ferguson, I have a question for you, sir.
yeah.
Your office issued me a letter asking me to issue subpoenas.
Right. I'll withdraw that because tonight,
I was going to ask you, sir, is there anything missing on this list that you don't have? I think all you really got was a copy of the building.
That's right.
I mean, is there other things on this list that
No.
that you require?
No, actually, most of the other things on that list were things we know they didn't have. We wanted them to say we don't have anything.
That was my other point.
Yeah.
I didn't know if they really
Yeah.
existed, sir.
And Ms. Ross addressed all those things perfectly, adequately. I would like us to respond to the timeliness. You have to follow the statute here, and the statute talks about when you have notice, or notice or knowledge. So on a Friday night, Friday late afternoon, is when they email to us the first set of preliminary objections, in which they allege it's not proven, they don't attach the building permit, they make a statement in there that a building permit was issued. We didn't see that until Monday, because it was a Friday night in June. We didn't see that until Monday, and we filed within the 30 days from when we had notice or knowledge. That's the statutory requirement, when we had notice or knowledge. And that's when we had notice or knowledge. But everyone in this room tonight actually witnessed the first time that we even saw the building permit when I pled for it before they presented the case. That's the first time we've seen that building permit, as far as I'm concerned, and we probably have 30 more days to file the appeal from tonight. If we had filed a right to know law request, it could have taken 35 days then for them to produce it. So, for those reasons, we, the email that we got on a Friday afternoon on June 12th was from Crown Castle. It wasn't from the township. The township's email corroborating the issuance of the permit without actually providing it to us was issued on June 19th, and we filed we filed before July 19th. So for those reasons, so on Mondays when we actually knew about it, and we thought it was the 30th. So I'm wondering whether the board wishes us to have any type of memorandum or something to submit after here, or whether the board's heard enough that they can make a decision on this.
No, we're going to ask you an issue with an opinion, sir. My last question to you, sir, we're dealing with the issue of dates and times, correct? You're claiming that the conditional use expired in, what is it, February of 2019?
May 7th, 2019.
The township, if I'm not mistaken, Ms. Moore, is claiming December 13th of 2019?
What I'm saying is, under legal analysis, that when the appeals ended in December of 2019 is a reasonable time for the time period to start on the conditional use. And they had then a reasonable time to seek their building permit after the appeal was finalized.
But you were counting that date when the appeal ended as the time.
That's correct, and that's consistent with the treatise that I shared with you all. That once the appeals are over and there's no further risk associated, then that's the beginning of the time period.
So the difficult
The other issue, Mr. Ferguson, we're dealing with is the issue of timeliness. June 12th to July 14th, whatever, correct?
Right.
So we're dealing with dates and times is what we're dealing with.
Yes.
Which is the correct date, which is the correct time. When does the clock start ticking?
Yeah, that's right. But there are, in the case of the expiration of the conditional use permit, there's an ordinance that's been in place for many years in Cecil Township that answers that question. And there's also a provision of the municipality's planning code that talks about when the appeal is due. What they're talking about is some scholar's opinion that ought to be different, but no court has ever found that. So you have to use the legal authorities that are in existence today, not the differing opinions of scholars around the world.